Welcome to the 12th annual fundraiser for Grassroots North Shore. The significance of our courts and judicial system cannot be overstated. In the first year of the Trump regime's attack on our rights and the rule of law, by and large, the courts have stood as the only branch of the federal government to provide a bulwark against this authoritarian assault. Judges of all philosophical perspectives have stood up for the rule of law, and many have paid the price with threats to them and their families. We've recently seen how our state Supreme Court can make or break our democracy through their ruling on redistricting that secured fairer maps in Wisconsin for the first time in over a decade. Grassroots North Shore remains your force multiplier, marshaling our members to win crucial elections. This year, we have the chance to secure a progressive majority on the Wisconsin Supreme Court through 2029 by electing Chris Taylor. We are currently calling and then sending over 9,000 postcards to strong Democrats who don't always vote in spring elections. This year, we have, and we're planning more actions for the fall elections to help flip 2 state assembly, 2 state senate, and 2 congressional districts so that our legislative branches can join the bulwark to save our democracy. And of course, we'll work to re-elect our awesome Assembly Representative, Deb Andraka. First, we'll hear from Senator Tammy Baldwin and Governor Tony Evers.
To my friends at Grassroots North Shore, thank you so much for giving me the opportunity to offer a few words at your annual fundraiser. I am so grateful for the work that you've done on my elections in the past, as well as the support that you've provided for other progressive candidates across Wisconsin. I've always believed that elections are won at the grassroots level. Neighbors going door to door to talk about the issues that matter to them and making sure that every voter turns out. Grassroots North Shore is at the center of that important work in Wisconsin. And that work is even more important now. We are in unprecedented times. It seems like every day we see a new attack on our democracy and our justice system from this administration. It's overwhelming, it's disheartening, and I think that's exactly the point. The administration wants to silence us. This makes your work at Grassroots North Shore so very important. I am glad that you are focusing your efforts this year on the Supreme Court race in Wisconsin. Electing Judge Chris Taylor to the Supreme Court is an important step we can take to ensure that our Wisconsin Supreme Court remains fair and impartial. Although a Wisconsin Supreme Court race can feel small in the face of challenges that we have as a country today, it is a concrete step that we can take to show the administration that we still value our rights and freedoms here in Wisconsin. Thank you again for all your support, and I look forward to seeing you soon in Wisconsin.
Hello, Grassroots North Shore. I want to take a minute to thank you for your incredible work you're doing in Milwaukee's North Shore to elect progressives who are fighting to make our state even stronger. We've had a lot to celebrate over the last few years because of your great work, and I'm counting on you again. I may not be running for re-election, but I'm going to do everything in my power to make sure we elect another Democratic governor in November and flip the legislature while we're at it. We have to get this done, folks. No matter who the Republican nominee for governor is, you can bet they'll get rid of the progress we made. They could restrict reproductive freedom, hurt our public schools, and dismantle our democracy ahead of the 2028 presidential election. There's so much at stake, and I know you're fired up to deliver big wins this November. With a new Democratic governor and majorities in the state legislature, there's so much more we can accomplish for working families and kids across Wisconsin. And I know that we have a lot of work to do before then. There are big elections coming up this spring, and I know you're already hard at work there. Thank you for everything you're doing. I know I wouldn't be here without you, and I'm so proud to have you standing with us. Enjoy your event, and I look forward to seeing you soon.
Want to thank Tony and Tammy for spending the time to bring us their message. Now we're fortunate to be joined live by our dynamic duo, Representative Deb Andraca and Senator Jody Habush Sinekin. They will each share a few words in support of Grassroots North Shore. First, we'll hear from Deb, followed by Jody.
State Representative Deb Andraca here. Thank you first and foremost for all that you do year in and year out to help elect Democrats. It seems like every single year we're saying this is the most important election, and here we are again, the most important election. I just want to give you a quick update from the Wisconsin Assembly and a quick overview of where we're headed. The short news is that the Assembly is planning to wrap up its business in February, by the end of February. That is your full-time legislature adjourning until 2027. So thank you for all of your help to elect Democrats who actually consider this a full-time job and want to do it full-time year-round as well. We have had lots of bills on immigration going back to February. So in February, Robin Vos himself introduced a bill trying to force county sheriffs to cooperate. We had another bill introduced by Representative Sylvia Ortiz Velez that would ban immigration from sensitive places. None of these have actually reached the governor's desk. We've also had a package of bills introduced that would keep families together and would bar state money from funding immigration. What we're seeing in Minneapolis is absolutely horrifying. We are doing everything we can to introduce legislation, but as you know, without a majority, there's not much that we can do to actually get it across the finish line and get it to the governor for signature. So this year is big, it's important. The legislature has never been closer. We only need 2 seats in the Senate and 5 seats in the Assembly. So I'm going to introduce our state senator to talk a little bit about what's going on in the Senate. Jody, are you there?
Hello, everybody, and thank you, Deb. I feel so grateful to be a partner with you in our efforts throughout this past year. And like you, I recognize how critically important Grassroots North Shore has been to us and building all the community that is so essential to our work. I must say, receiving Nancy's emails is a balm to my soul because she really does speak to the issues of the day, coalesces them, and allows us to identify action items. So thank you for that and all these events and the community and support I feel from Grassroots North Shore. As you will keep hearing today over and over again, we most certainly do need that Democratic majority in our legislature. It is unbelievably important and will be a game changer. And let me just share with you why it is so important and what I have seen in my first year as a state senator. Without the majority, important bills have not been able to proceed. And I just have seen the contrast over and over again. Many of you might have heard about my hard work on the data center accountability bill. Over 6 months of work, building coalitions across the state with stakeholders and environmental and labor groups, worked on it, 11 different bill drafts. We got it out there, widely well received. The Republicans introduced their bill after not 6 months, but 6 days of work, didn't do any vetting or any stakeholder input process, and it doesn't even address the very concerns that they said it would. Take Knowles Nelson. This is something that for the past year, we have been working so hard on to maintain the integrity and the continuity of this very popular, long-standing bipartisan program. And I have been at it week after week, and most certainly including up to last Friday and again tomorrow, where I am having to deal with the Republicans' efforts to just cut and pick away and undermine the integrity of the program. Again, with a majority, we wouldn't have to go through that bologna sausage, but we are there. Again, we know about childcare, and just last week with my interfaith security bill, we did get a public hearing, which I know is very rare. We had faith groups from all over the state speaking to the importance of this program, but guess what? We need a public hearing in the assembly also. And what I heard is that the assembly chair is not feeling like he wants to do so because he wrongly feels that the interfaith security bill would interfere with ICE's ability to go after folks who are seeking refuge in churches. So all these examples just underscore what you already know, is that we must get to this majority. And I'm confident with your help and others around the state, we will do so. So here's to a really great year. And thank you again for all that you do and all of your supporters building the community that we have together. Thank you.
Thank you, Deb and Jody, for your inspiring words and all your hard work. Can't be easy going into that legislature these days. And now I would like to introduce our development chair, Debbie Patel, who will introduce our three wonderful guest speakers and moderate the discussion. Debbie?
Thanks, Cheryl. We are fortunate today to have three excellent speakers, Jeff Mandel, Mary McCord, and Paul Kiesel. We will hear from each of them separately, and then I will moderate a panel. We got lots of questions, probably more questions than we can cover, but we will try. Our speakers are all lawyers who are dedicated to defending democracy, and I am pleased to introduce the first, my friend Jeff Mandel. Jeff is the founder and president of Law Forward, Wisconsin's only pro-democracy nonprofit law firm. Law Forward uses strategic litigation to ensure that in Wisconsin, democracy includes all of us. I met Jeff just after, perhaps even before, Law Forward existed, and I've remained impressed ever since. Jeff is widely recognized as one of Wisconsin's leading experts in election law and constitutional litigation. In 2020, Jeff played a lead role in repelling the bevy of attacks against Wisconsin's election results. He has handled a variety of high-profile cases before the Wisconsin Supreme Court, including on absentee ballot drop boxes, indefinitely confined voters, attempted purges of the voter rolls, separation of powers, and other issues. Wow, Jeff. And I end by saying that Jeff represents me and two other plaintiffs in a lawsuit against Elon Musk, who backed a brazen scheme to bribe voters in last year's Wisconsin Supreme Court race. Take it away, Jeff. Thanks for being here.
Thanks so much, Debbie, and thank you to you all for the invitation. It's wonderful to be back. I know that among the Grassroots North Shore membership and community and the participants here today, I have many friends, and Law Forward has many friends, and it's wonderful to be with you. I want to just speak for a couple of minutes because there are so many more interesting things that that our panel is going to talk about. But I just want to emphasize that when the news is dark, when we do day in and day out feel that shock and that horror that was so well represented by the art earlier, I hope that we can take some comfort, and this group really deserves to take significant comfort in the fact that Wisconsin is one of the few bright spots. Wisconsin is a place in the midst of a national tide against democracy. Wisconsin is a place where democracy is actually growing and doing better. Yes, we are subject to the same difficulties from the administration and from national policy that we see elsewhere. But Wisconsin, in our state work, is actually headed in the right direction. Cheryl mentioned breaking the gerrymander, and that we have a legislature that is moving back toward being a deliberative body and policymaking forum. We have a Supreme Court that is no longer rigidly knee-jerk ideological, but is thoughtful and taking cases on their own terms and building the law in a way that emphasizes our state constitution and the rights that it provides. And we have a public that is engaged in this. Remember that in 2024, Wisconsin is the only place in the country where voter turnout went up. Uh, Not just because this was a deeply important election, not just because Wisconsin was, as always, the potential tipping point state, but because of the end of the gerrymander, because of the revitalization of democracy in our state legislature, we saw an outpouring of candidates that once the races were no longer predetermined, people wanted to run and people wanted to participate and people wanted to represent their neighbors. And we saw that voters responded. And when the races were no longer predetermined, they showed up to vote. There is a tremendous amount continuing to happen of good here in Wisconsin. And we'll talk about that some. But we also, of course, we live next door to Minnesota, which right now is the epicenter of so much that is scary and bad. We've seen our own challenges here in Wisconsin with the prosecution and conviction of Judge Hannah Dugan, um, with continued efforts to crack down on our democracy. There is, as I say, much grounds for hope. We can talk about some of that through the panel. We can talk about some of the litigation that Law Forward is pushing to continue to improve the prospects for democracy here in Wisconsin, including, of course, the case against Elon Musk, where Debbie is one of our intrepid plaintiffs, including the case to end the congressional gerrymander in Wisconsin, which continues to distort our state's representation in the U.S. House of Representatives, including additional voting rights cases, electoral reform cases, state constitutional cases, and a couple more that I can't quite talk about yet, but that you'll know about by the end of the month. But before we get to all of that, I want to introduce, I'm really thrilled to get to introduce to you a good friend, both of mine and of Wisconsin, Mary McCord, who is the executive director of the Institute for Constitutional Advocacy and Protection at Georgetown Law School. I first met Mary a few years ago. One of my law school classmates and good friends works at ICAP with Mary and had reached out to say, is there something we could do in Wisconsin? Is there some way we could be helpful? And we were looking to bring a case and deal with the fraudulent electors who had decided they knew better than more than 3.25 million of their neighbors, and that they were going to try to steal Wisconsin's 2020 electoral votes. It was a real privilege. It was a lot of work, but it was also a lot of fun over a couple of years to work really closely with Mary and her team, who were our co-counsel in that work. Many of you know Mary through her podcast. The work that Mary and the ICAP team do is really phenomenal. They are litigating around the country. They are also at the forefront of educating lawyers, policymakers, and citizens about how to protect themselves from anti-democratic actions. And I'm really thrilled that Mary could join us tonight. So I'm going to turn it over to her.
Well, thank you for such a gracious introduction, Jeff. And I'll say to everyone there, it was litigating that case against the fraudulent electors and the attorneys that came up with the plan, the scheme, and really directed them and encouraged them to engage in it. It was during that case that I got to visit Madison, and I'd never been there before. And it was right around the holidays, and the Capitol was all dressed out for the holiday season, and the lights were on. And other than the fact that it was really cold, it was a lovely time. And I have a whole warm feeling about Wisconsin. Right now, I will tell you, though, there's nothing warm about where I am in DC. We've broken a record now for lowest sustained temperatures, and I'm sure you would all laugh at us if I told you what those temperatures are, so I'm not going to do that. I want to talk a little bit about the rule of law because I think it's a topic that gets bandied around. It's a phrase that gets bandied around a lot. And I don't know if everyone really knows what we mean when we talk about rule of law, because rule of law is under threat right now. And so I want to give you a framework to think about the rule of law and think about the way things have happened in the past year. You know, Americans are really comfortable talking about due process, like individual rights. And in fact, all 9 members of the Supreme Court agreed earlier this year when the Trump administration tried to put a bunch of alleged members of Tren de Aragua on a plane and spirit them away to a Salvadoran terrorism detention center in the middle of the night, that was a violation of their due process rights, that they were entitled by virtue of the Constitution to notice within a reasonable time and in such a manner that they could challenge being expelled from the country that way. So due process is something we are familiar with, but how does that fit in with the rule of law? It's more than due process. It's a system, 4 prongs I'm going to mention and then tell you what they mean when we think about what's happening in our country today. First is a system of laws by which both the governed and the government agree to abide. Second, transparency in the enactment and the enforcement of those laws so that there is predictability and stability. Third is a fair legal system in which rights and responsibilities are evenly adjudicated. And fourth, and directly related to that, is diverse, competent, and independent lawyers and judges. And all of these things are under threat under this administration. If we want to preserve our individual rights and due process for those individual rights we care about, we've got to preserve the rule of law. So let's look first at a system of laws by which both the governed and the government agree to abide. So that starts with that starts with the Constitution in America. President Trump began his second term, the very first day of his second term, by purporting through executive fiat and executive order to reinterpret the 14th Amendment's citizenship clause in a way that's inconsistent with its text, with Supreme Court precedent that interpreted its text that's over 125 years old, and with the historical practice of granting birthright citizenship. But the president didn't have any authority to change the Constitution, nor did he have any authority to ignore a congressionally enacted statute that also memorialized birthright citizenship, or to ignore Supreme Court precedent. Because in our constitutional democracy, it is Congress, not the president, that wields the legislative power. It's the judiciary, not the president, that says what the law is. The president also dismantled government departments and agencies created by Congress. He impounded funds that had been appropriated by Congress, and he fired Democratic appointed members of bipartisan boards of independent agencies, including his attempted firing of Federal Reserve Board member Lisa Cook, even though this was in violation of 90-year-old Supreme Court precedent. But again, the Constitution gives Congress, not the president, the legislative authority to create departments and agencies, the power of the purse to appropriate funds, and it gives the judiciary, not the president, the power to interpret the law. The president has imposed enormous tariffs on goods of all kinds without any statutory authority, again, even though it's Congress and not the president that has the power to lay and collect taxes. The president sent the National Guard to U.S. cities without meeting the statutory requirements that Congress had enacted, even though it's their prerogative to do that, and even though it's Congress under the Constitution that has the power to provide for the calling forth of militia. And then, of course, pertinent to what's happening to your neighbor in Minnesota, the president has surged DHS agents into so-called blue states and blue cities, where these agents have engaged in racial profiling. They've detained people without probable cause. They've used excessive force, not just against suspected undocumented residents, but also against protesters engaged in First Amendment activity. And they have even killed protesters. These surges have raised multiple constitutional issues, including 10th Amendment issues, because it is the states that hold the police power and the responsibility under the 10th Amendment for providing for the health and the welfare of their residents. All powers not reserved to the federal government, not given to the federal government by the Constitution, are reserved to the states. As any review of the hundreds of court cases against the administration will show, this list just goes on and on. Second, transparency in the enactment and enforcement of the law so that there's predictability and stability. Now, I will say, this executive branch is actually very transparent in enforcing the law. They openly prosecute perceived political enemies like former FBI Director James Comey, New York Attorney General Letitia James. Now, more recently, they've opened investigations into the chair of the Federal Reserve Board, Jerome Powell, for not reducing interest rates fast enough. And of course, open investigations also into Governor Tim Walz and Mayor Jacob Frey for speaking out about the ICE and CBP raids. At the same time, they've shut down a criminal investigation into border czar Tom Homan, who was allegedly recorded back in September 2024, accepting $50,000 in cash in a kava bag for agreeing to steer border enforcement contracts to those paying if Trump were elected. Trump has also blacklisted law firms for representing perceived political enemies, litigating against his priorities, and at the same time withheld such treatment from law firms that change their hiring and case selection practices and provide millions of dollars in pro bono legal services to the president's preferred causes. He's targeted universities for investigations based on failing to do enough to prevent anti-Semitism while dropping investigations of those that capitulate to his demands to eliminate DEI. So we have predictability and stability, but the predictability and stability we have is knowing that those who challenge this administration will be punished, will be retaliated against, while those who subjugate themselves will not. That is not what's meant by the rule of law. Third, a fair legal system by which rights and responsibilities are evenly adjudicated. This means we have got to preserve the adversarial process that's the cornerstone of America's legal system. But when a president retaliates against law firms that he believes has wronged him, aiming to shut them down by cutting off their access to federal government, stripping their lawyers of security clearances, he's attempting to coerce them into declining to bring cases that challenge his authority or to represent people and causes he dislikes. But he doesn't just chill those lawyers. In fact, those lawyers have fought back. They've gotten court-ordered injunctions in every single instance. But he chills lawyers at other law firms. And the result is fewer attorneys and law firms who are willing to contest the president's executive actions, neutering the adversarial process that relies on competent lawyers on both sides to represent parties on both sides of a dispute and to present evidence and legal arguments that allow judges to render informed and fair judgments. And we've seen this, and I'm sure Jeff has seen this in some of you. The law firms that used to do pro bono work are doing far less of it right now, and the burden is shifting to nonprofit legal organizations like ICAP, like Law Forward, where Jeff is. Finally, fourth, diverse, competent, independent lawyers and judges. The administration has fired career DOJ attorneys for doing their jobs, replaced them with attorneys willing to act on the president's grievances and sacrifice their professional responsibilities to pursue political prosecutions. It is right now, I don't know if you saw this just a few days ago, openly advertising for lawyers who want to advance the Trump agenda, not who want to advance justice, but advance the Trump agenda. It has caused DOJ attorneys to misrepresent facts to the courts, including in that case about the expulsion of alleged members of Tren de Aragua when they misrepresented whether planes had already taken off or not when the judge ordered them not to. It has fired top lawyers in the U.S. Armed Forces in order to prevent, and this is a quote from Secretary of Defense Pete Hegseth, to prevent any roadblocks to orders that are given by a commander-in-chief. The president himself has called for a judge who ruled against him to be impeached, the very judge who ruled against him in that Tren de Aragua case. And of course, the DOJ has prosecuted a state court judge right in Wisconsin, seeking to chill other judges who are trying to manage their courtrooms, provide due process to everyone in front of them, something that is constitutionally required in the face of disruptions by ICE coming into their courtrooms. The president and his allies, they claim expansive power is warranted by the outcome of the 2024 election, but that is not the way that our Constitution works. That's not the way our democratic republic works. It's the founders separated governmental power between three equal branches. and claiming an electoral mandate to steamroll two of those three branches, pursue political prosecutions, eliminate the opposition, conflicts not only with the framers' intent, but also with the republicanism that is espoused by many conservative organizations. Elections have consequences, but to sustain our democratic republic and to protect our individual rights requires the government, like the governed, to abide by the rule of law. I look forward to having more of a discussion with you about all of the things that Jeff and I and our next speaker is going to talk about, and I will introduce him now. Unfortunately, I don't know Paul Casale. I have not met him, and so I apologize that I can't give quite the same warm introduction to him of him that Jeff was able to give to me because of our having worked together. But Paul is a plaintiff's side trial lawyer in California. He formed Speak Up for Justice last year to address the silence from the legal community about threats to judges, law firms, and the rule of law. Some of the very things I think that I was just talking about. The organization has representatives from both state and federal courts addressing these issues, with notable speakers giving presentations online and in person. And I am deeply appreciative of the work of Paul.
Thank you so much, Mary. What a great introduction. And quite frankly, that presentation you just gave was spectacular. It was incisive and to the point and incredibly valuable to everyone who listened to that. And I hope we have a chance to work together, because I'm impressed by your fund of knowledge and your ability to articulate so brilliantly kind of the rule of law as you did. And to be clear, what got me motivated was, as the executive orders came down, the first thing the administration went after was law firms. They went after the Paul Weiss Rifkin law firm, seeking like what I call a fatwa against that firm, and seeking to take away their classified rights to information that they'd had for decades. And ultimately, they relented. They took a knee to the administration, and when that happened, the administration began to go after other law firms, silencing them, having them commit to pro bono legal services for the administration. And no one was speaking out. No one was saying this isn't right. No one was saying this is not how democracy is supposed to work. And so that was the genesis of Speak Up for Justice. It was both speaking up for the law firms that were being silent, and for our judiciary, who themselves were being threatened, and in fact are being threatened by the administration. But for all of you, I think the most interesting thing is yesterday, District Judge Fred Beery from Texas issued a brilliant 2-page decision rebuffing the administration's attempt in the Adrian Arias deportation efforts, where his 5-year-old son was taken into custody along with his father in Minnesota, and he was immediately transferred to Texas to try to put him in a more friendly environment for the administration. But they did not get a friendly judicial officer when a federal district court judge was asked to please release Mr. Arias and his 5-year-old son. By the way, Mr. Arias was going through the appropriate political asylum request. He'd followed the letter of the law. He'd done exactly what he's supposed to do to seek residency in the United States based upon a claim of asylum from the nation he was coming in from. I want to read you, because it's just so incredibly incisive and valuable, and really speaks to the rule of the law, what Judge Beery issued just yesterday in essentially commanding the government to release Mr. Arias and his son. He says, in part, the case has its genesis in the ill-conceived and incompetently implemented government pursuit of daily deportation quotas, apparently, even if it requires traumatizing children. The court and others regularly send undocumented people to prison and order them deported, but do so by proper legal procedures. Now get this. Apparent also is the government's ignorance of an American historical document called the Declaration of Independence. 33-year-old Thomas Jefferson enumerated grievances against a would-be authoritarian king over a nascent nation. Among others were, here you go. One, this is what the king was doing. Quote, he has sent hither swarms of officers to harass our people. Two, he has excited domestic insurrection among us. Three, for quartering large bodies of armed troops among us. And four, he has kept among us in times of peace standing armies without the consent of our legislature. We, the people, are hearing echoes of that history, said Judge Beery. His last comment was, with a judicial finger in the constitutional dike, Adrian is ordered released. So that is what the rule of law is all about. Implementing the constitutional protections that all of us as American citizens have and are entitled to rely upon. Speak Up for Justice is a nonpartisan organization. We have people on the left, we have people on the right, as should be appropriate, because the idea is to preserve our constitutional form of government. Let me just say this. Our constitutional structure provides for guardrails. We have the executive president, we have the congressional component, the legislature is number two, and we have the courts. Those are our guardrails right now. Congress and the courts. Right now, Congress is no guardrail at all. It's a cliff with no guardrail, and the courts themselves are the last remaining vestige of what we need to support our democracy. What you do in Wisconsin is so critical. Maintaining the balance of your Supreme Court is so essential that even though I live in California, and I apologize for my non-virtual background here because it's a beautiful day in Southern California, California is the fourth largest economy in the world. We're a donor state to the rest of the nation and yet take a lot of abuse from Washington, D.C. Wisconsin is the straw that we need to maintain our democracy with. And I'm just deeply grateful that you give me an opportunity to speak with you. Speak Up for Justice. If you go to speakupforjustice.law or just type that into your web browser, you'll see all the programs that we put on so far, which have included retired Supreme Court justices. Our last panel involved 4 U.S. attorneys who've all left the U.S. Attorney's Office. And the program we're going to be doing on February 26th is going to be talking about impeachment and the way the administration and Congress, quite frankly, Ted Cruz, is trying to use impeachment as a way to intimidate judges from doing their constitutional job of independently evaluating decisions before them and not making political outcomes the result. With that said, I'm happy to respond to any questions you might have, Debbie, or stand down.
All right, we're going into our panel, and I'm extremely excited to have this group of 4 amazing scholars and me together in the same space. We have questions that we got from audience members, but I wanted to start with a couple of things that your comments led me to think about. I'm going to start with a quick one for Jeff. Based on what you heard both Mary and Paul say, how important is Chris Taylor to democracy, getting her elected this spring?
Well, as Paul just said, making sure that we have a Wisconsin Supreme Court that continues to be thoughtful and open-minded, I think is really crucial. There will presumably not be the kind of attention and the kind of influx of money in 2026 that we saw in 2025, because this election, no matter who wins in April, is not going to change the ideological balance of the court. But Chris Taylor is talking about democracy and the rule of law, and appreciates and understands these things in a way that it's not clear the other candidate is. And these elections matter a great deal. We have an election for the Wisconsin Supreme Court every April now, from now until 2030. So this is a big deal, and people should be thinking and talking about it. Many of the folks on this call live within the boundaries of the District 2 Court of Appeals, and that race is not even contested. We'll have a new judge on the District 2 Court of Appeals. So energy and enthusiasm, talking about why the rule of law matters, echoing the things that Mary's talking about, that Paul's talking about judicial independence, making sure that your neighbors know we have this election in April. This is all really, really important.
Okay, and then I would not be the head of the development section of Grassroots North Shore if I didn't, of course, point out that donations that you make through this fundraiser will go to help get her elected. I want to talk about the Hannah Dugan case, and it is seen as a new challenge to judicial autonomy. I was going to start with Jeff, but since I already did that, I'd like to turn to you, Paul, about whether you followed the case, I'm sure you did, what it says to you about challenge to judicial authority. I have to tell you, a lot of us were down there protesting in the cold in the summer or whatever. We're very engaged in that particular case. And you may or may not know that her attorneys have filed for either a dismissal or a new trial. But tell us what this case tells you about the threat to judicial autonomy.
Well, it's interesting, and I've followed the case very carefully. When it happened at the outset, I have a lot of federal judges I'm working with on our Speak Up for Justice program, and we were horrified that a state judicial officer was taken into custody by immigration authorities, allegedly for committing a crime. And of course, she was tried and apparently convicted of the violation they were accusing her of. And yet, the courts need to be a safe sanctuary. You need to be safe when you go to court. You need to be able to go to court to seek your political asylum and not be arrested when you're coming out, because that's what they've been doing here in Southern California. They've been getting people to come into court as they're supposed to do, make their petition, and then they get taken into custody and booted out of the country. And so what's happened in Wisconsin is scary because it's a threat to judicial independence. There's some subtleties of that particular case that raise some issues regarding, compliance with a warrant and what you need to do as a judicial officer and recognizing the authority of someone who has a warrant to make a lawful arrest. And I won't wade into that, but I will say when ICE has somehow granted itself the right to issue a warrant without judicial oversight or review. But I think Judge Beardy said it's the fox guarding the hen house, and that's the danger we have. Mary, your thoughts on that?
Yeah, without getting into sort of like the specific facts of the case, because this was all very tailored to whether she had essentially done anything to try to, obstruct ICE or I don't know if it was ICE or CBP, who is actually the ones that were there in the courtroom, but whether she had actually done anything to obstruct them from carrying out their mission. To Paul's point, having ICE in courthouses is just a problem, right? I mean, the fair adjudicatory system I talked about depends on the community being willing to be part of our judicial system, right? Because jury trials require jurors. It requires people to come to court without fear of what might happen if they come to court, without fear of what might happen to others who may come with them. It requires defendants to show up in court without fear of ICE. It requires witnesses to show up in court without fear of ICE. And so it's really hard, I think, for our court system to fairly adjudicate the matters in front of them while these other things are going on. And I think it's an area that state courthouses across the country are really grappling with right now. And this case is a very unfortunate example. And, arresting her in a parking lot and hauling her away instead of a judicial, just giving her a summons, that also just offends me deeply, because this is not some sort of violent, person who's been violent that needs to be treated that way.
Well, I
There's a
think,
lack of humanity right now, is what we're seeing from the Department of Justice and the Department of Homeland Security.
and I do think it was meant to have a chilling effect, right? I mean, the way they did it, much of what they do, they mean, I mean, that is the intent, right? Cruelty.
100%.
So, Jeff, do you have any thoughts to add?
Let me just note, I mean, Mary and Paul have hit on the main points, but let me also just note the profoundly anti-democratic nature of this, right? Recall that here in Wisconsin, for better or for worse, or more likely for better and for worse, we elect all of our judges. And the people of Milwaukee County had chosen Judge Dugan, and they have now been sort of deprived of that of her service, both for essentially a year while this has gone on, and now, potentially permanently, because the legislature, the legislative leadership, I should be clear, um, pushed her to resign even before this process has concluded. And so they said, now uh, she has been convicted, although, of course, a judgment of conviction hasn't been entered. There are post-trial motions and things that, as you mentioned, were just filed. But the moment the jury verdict came down, they said if she doesn't resign, the first thing we're going to do when we come back after the holidays is we're going to impeach her. And she has resigned, and now someone else is sitting in that seat in that courtroom. But it's a real attack on democracy. It has a chilling effect on other judges. It is meant as a message, but it is also impairing justice in Milwaukee County in the meantime.
Thanks. And thank you, Paul, for kicking the question after you answered to Mary. That's what I want going forward. So thank you for setting the stage for that. So I'm going to kick this one to Mary. Someone asked, can the federal courts act to limit military activities if Trump invokes the Insurrection Act? So what I would like you to do is, I know you're a law professor, can you explain the Insurrection Act for us a little bit? Answer the question, and then I mentioned before that I heard this morning, I told all of the panelists that I listen to podcasts while I swim. I swim much harder when I'm listening to these because I work much harder, sometimes because I get like really whatever. But Michael Waldman at the Brennan Center said that invoking the Insurrection Act is a big if for Trump because he might be told he couldn't do it. So anyway, can the federal courts act to limit military activities if Trump invokes the Insurrection Act? And do you think he will?
So I think that there's a good argument that the courts can limit that. I mean, we saw the courts limiting it when it came to his use of the National Guard in LA and in Portland and in Chicago under a different authority called Title 10 United States Code Section 12406. That's what he used in those places. He did not use the Insurrection Act, which he could have tried to use, and in which he had basically been promising even since before he was elected that he would invoke on day one. You might recall he said that a number of times, and he didn't use it. And courts, when that was challenged, they did say that even though there's a lot of authority in the president for making determinations about whether these things are warranted, that authority is not unreviewable, and that courts can review what the president does to see if it is done essentially in good faith, if it is a colorable assessment of the facts using honest judgment. So what does all of that mean? Let's back up a little bit, Debbie, because you said give a little bit of overview of these things. I want to start with the Posse Comitatus Act, right? There is a federal law that bars active duty military and National Guard units, if they've been federalized, from engaging in domestic law enforcement. And this goes all the way back. I mean, the law doesn't go all the way back to the founding. The law was passed actually you know, in sort of in the context of a lot of racist activity post Civil War, but the concept of not wanting to have standing military doing domestic law enforcement was fundamental to the founding fathers, right? I mean, they were escaping a place where there'd been, you know, just and actually here in the United States before it became the United States, where you had military from Britain here enforcing, you know, the law on the streets, and they didn't want to have that. So this concept that the military should not be enforcing domestic law is really, you know, part and parcel of our entire history as America. And what that means when I say domestic law enforcement, that doesn't mean that they can't, you know, support law enforcement or support others, but they can't like do the core things we think of as domestic law enforcement, right? Search, seizure, arrest, detention, what the police do, right? Those are police powers at that state and local level. And like I said, that applies to our active duty, you know, actual armed forces and also the National Guard when they've been federalized. Because some of you may be thinking, well, wait a minute, National Guards sometimes do enforce domestic law. And that's because when the National Guard is in state status, when the governor calls up the National Guard for something, he's not bound by the Posse Comitatus Act. And in state status, even though they usually don't really enforce state law, they're not prohibited from doing so. But when they are federalized, either under the Insurrection Act or other provisions of law, then they can't engage in this kind of domestic law enforcement. So the Insurrection Act, unless there is an express constitutional exception or a statutory exception. There is no express authority in the Constitution that allows the president to say, military, you can just engage in domestic law enforcement. There is an express authority in the Insurrection Act, and that allows, in a variety of circumstances, the president to federalize the National Guard and use active duty military where there is an insurrection or a rebellion against the authority of the United States, or something that makes it impossible, not just something, a rebellion in a way that makes it impossible for federal law to be enforced. It sounds a lot like some of the things at issue in those 12406 cases, that other authority he used in LA and Portland and Chicago, but it's a separate statute that is recognized as an exception to the Insurrection Act. It's only been used 30 times in our history. And in almost all of those cases, it was at the request of the governor, because there's a provision that says when the governor or the state legislature requests it, because the governor is feeling like he cannot adequately maintain the peace in light of riots or rebellions, etc., he can request it. So the last time this happened was after police officers were acquitted for the brutal beating of Rodney King out in California. Many of you will remember that, and that sparked huge riots that resulted in many deaths. And at that point, the governor requested that the president invoke the Insurrection Act. The only times it's not been used at the request of the governor or state legislature is right during the civil rights era, when there were court orders, right, to desegregate the schools, and some of the southern states refused to obey those court orders. And a few presidents invoked the Insurrection Act because the state was actually standing in the way of enforcement of court orders. Those are the only times we have. That's the precedent there. But there is some law, including from the U.S. Supreme Court, that does suggest that the authority a president has to invoke it is not without review by the judiciary. So the administration wants to say when he decides that the situation warrants, it's an insurrection, he can do whatever he wants, but there's some authority, and this is the same authority that was used by the courts in LA and Portland and Chicago, the same authority that they used to review those federalizations of the National Guard. And that is whether the president's view of the facts on the ground, right, whether there's an insurrection or rebellion, is a colorable assessment of the facts in an exercise of honest judgment. So we do think this would be reviewable. Now, whether I think he'll do it or not do it, I'm sort of surprised that he has not done it before. I was surprised when he used 406 instead of the Insurrection Act when he first federalized National Guard in LA. And he's gotten a lot of wins out of the Supreme Court. So I don't know that he's too worried about losing there, except the loss in the Supreme Court on the use of 12406 has got to make him at least a little bit concerned about that. But, you know, predicting what this president is going to do is really difficult because he changes his mind very, very quickly.
So, Paul, I'm curious, do you have anything to add? I mean, as I was listening to Mary, I was thinking both Mary and you live in places that were overrun by, by ICE. And, I mean, you sort of you both have lived through it. In Wisconsin, we're trying to get ready for it. But so do you have anything to add, Paul, to that? Your thoughts? Or
So let me start by saying I'm humbled by Mary and Jeff's fund of knowledge on our constitutional. It's amazing. I'm sitting, I'm learning myself stuff. So thank you for this. It was great. To be fair, my wife and I lived in Los Angeles when the Rodney King riots started in 1992. There were fires burning all around us. Literally, we had our neighbors took cars and put them at the end of our streets because there was that much danger in our community. There were people being shot and killed all around us. So and I hadn't realized the National Guard, I knew that I think it might have been Governor Wilson. I'm not sure who the governor was that issued it, but I didn't realize that it was the Insurrection Act that was used. I just thought he was using his power as the governor to call up the National Guard. So it's interesting that it was the governor who asked the president to dispatch the National Guard. But to be clear, I was relieved because there was no fire, there was no police, there was nothing, because there was so much violence happening around us that but for the National Guard coming in and bringing law and order back to our community, we live in Beverly Hills today because of what happened in 1992. We moved here in 94 because Beverly Hills was a place that was protected. Its law enforcement were in place and provided social services that LAPD did not. So I appreciate then the need to have the Insurrection Act. I'm fearful that this president might try to use that as a way to federalize the National Guard, and that would be very scary indeed. But it's enough to say that the National Guard has a very important place. It's not to support ICE. It's not to come to California to guard federal buildings and literally camp out in the courthouse. They were literally sleeping on the floor of the federal courthouse because there was no place to put them up. That's not a way to run a government. That's not a way to have law enforcement behave in a community. So I'm thrilled by what's happening in Minnesota, that people are reacting in a peaceful way. But that's what we need to do as a country. We need to respond peacefully, but aggressively. We need to get out there in the streets and speak our minds. The No Kings rally was not a left or right. It was essentially people speaking up for our democracy. And I was proud to be on the streets with thousands of others just in support of our constitutional structure.
So I'm going to say this here, and then Cheryl, you can correct me if I'm wrong, but for people in our audience, if you don't know, the date of the next No Kings rally is March 28, I think. So Cheryl, check, because I'm on camera now, but check and correct me if I'm wrong, but there has been a date set. And what I think is interesting about Minneapolis, which is my hometown, and it's been really distressing to watch, is that the feds came and created the chaos and created that. And now the thought is, okay, now that we've created chaos, we're going to use the Insurrection Act, to go in, which, Mary, I think is a reason why we should have judicial review to sort of get at the cause. Jeff, unless you have something to say, I'm gonna move on to the next question. And this one is for Paul. The webinar with former U.S. attorneys and the politicization, I worked on that. I was tripping over that when I talked to him before, of the Department of Justice is very worrisome. And I'm sorry, I listened to your webinar about that this morning during my swim, I think, or it was one of these days while I was swimming. Is the FBI, the particular question, and I want you to address this, but you can, make it more global as well. Is the FBI taking over the investigation of the Renee Good case unusual Is it possible to get a fair investigation without state review and participation? And I have to say that you guys may be more up to speed about where these cases and the FBI role and everything than I am. But how do you feel about how things have been handled in Minnesota in terms of looking into the two, I'll call them murders because that's what they were. So what?
Well, look, they were murders. And in fact, we just came back from Germany. My wife and I spent 2 weeks in Germany, and they refer to the Holocaust as murders. That it is merely everything is murder. And
Yeah.
quite frankly, what happened to Renee Good, what happened was murder, pure and simple.
Right.
It is. I'm going to defer to Mary on the constitutional structure. My impression, my belief, is that the FBI has no role in investigating this state act, this violent act that was committed. And from my view, the FBI is merely an attempt to whitewash and protect the ICE agents who likely lack training and use of force. I've had cases in California against the California Highway Patrol where my client was shot and killed behind the wheel of his car. He was driving his car and they were threatened. They really were not, but they shot and killed him. That's a violation of policy. You never shoot someone when they're driving a car because the harm happens merely by shooting your weapon into a motor vehicle. So I do not believe that the FBI should take over this investigation. It should be left to local law enforcement to investigate, to do a fair and impartial evaluation. But it's enough to say this: 5,000 assistant U.S. attorneys, AUSAs, have resigned in the last year. That is an untold, huge number of bipartisan, hardworking lawyers who left the Justice Department because it wasn't the Justice Department that they actually joined at the time they became members of that. And Todd Blanche last month had his fireside chat where he said, we are at war. Speaking about the judges, we are at war with the courts, and we need you young lawyers to come and join us at the Justice Department. And that kind of messaging scares the hell out of me.
Can you talk a little bit, elaborate about the U.S. attorneys, about what they traditionally have been and what Todd Blanche wants to turn them into?
Well, traditionally, they have been impartial evaluators of the constitutional structure. They indict where appropriate. They actually go through the proper mechanism for indictment using grand juries and having the process work. I think there've been several circumstances in the last few months where they've not used the grand jury the way it was intended to be used, whether it was to indict James Comey. Jim Carrey, the actor, was not indicted. And so
It could be. I mean, you know,
you never know.
crosses
Exactly.
Trump.
Yeah. So, I mean, that's the design of the Justice Department, is to be the independent, neutral arbiter of what the law is. And the way they're being used now is merely as functionaries to carry out the administration's desire to affect its own will on our legal system, and not how it had been done traditionally.
Debbie, could I just jump in on this? Because I spent 20 years as a federal prosecutor in DC and then 3 years at Maine Justice. And so,
by the way, fabulous podcast. So if people aren't listening, they really need to. Go ahead. I'm sorry to interrupt.
So it's called Maine Justice. I do it with Andrew Wiseman from the perspective of two former federal prosecutors. You're right, Paul, that state and locals would usually be, investigating whether there were violations of state law. But there is normally a role for FBI, because normally if there is an officer-involved shooting, particularly one that results in death, the Civil Rights Division of the U.S. Department of Justice will investigate that to see if this was a violation of civil rights. And so what's really remarkable about the Renee Good case is the Department of Justice and the Civil Rights Division Assistant Attorney General immediately, with no investigation, said that this was a justified shooting and they were not going to open a civil rights investigation. So at that point, there really isn't very much reason for the FBI and certainly not the Department of Homeland Security. I mean, talking about the fox guarding the henhouse, to be doing an investigation. But instead, they did announce, the Civil Rights Division announced they would be in the Department of Justice that they would be investigating Ms. Good's spouse, Rebecca Good, and other activists to see if they were involved in domestic terrorism. So my guess is the U.S. Department of Justice would say this is why the FBI is still maintaining the evidence, because they're doing this other investigation. But it's not normally, the reason this doesn't usually happen is because normally the federal investigators and the state and local all go in and they work cooperatively with each other, and they make sure that they preserve all the evidence and they coordinate with each other. And DOJ may want to go first, and often does if they're doing a civil rights investigation, but they don't block out the state and locals the way that we're seeing in Minnesota. And as for AUSA's resigning, I mean, many of the people who have left are people who I've worked with throughout my career, and it is not the same Department of Justice that it used to be. If they do not bring a prosecution that they feel is not warranted by the facts, that does not meet, that they don't have sufficient evidence to prove every element of the offense beyond a reasonable doubt, and they refuse to do it, they lose their jobs and they get replaced. And so some just quit so they don't have to be put in that position.
Thanks, Mary. And I have to say that listening to the two of you talk about this, and I told you I'm from the Twin Cities, and my dad was a federal law enforcement officer. And so as a child, I met some federal judges and I met U.S. attorneys. And that's part of the reason I think I went to law school. And it certainly didn't work that way from my memory. This is all really has been like almost too much for me, and I'm not in the business the way you guys are. So we're going to talk about something hopefully a little bit more pleasant now for a couple minutes, and we're going to kick it back to Jeff. And Jeff, someone said or asked, how can the courts protect elections if Trump cancels them? And and they said cancels them, citing an insurrection. And we've talked a bit about the Insurrection Act, but I would like to ask you if you think, I hope I know the answer to this, if you think the 2026 elections will actually move forward, and whether you think in Wisconsin they're protected and they'll go pretty well.
I do think the 2026 elections are going to move forward. I do think that we will continue to have free and fair elections here in Wisconsin. Remember that elections are administered by the states. Now, that doesn't mean that I don't think there might be shenanigans and attempts to interfere. I do think we will see some of that. So let me address your question in a few ways, and then Mary might have things to add. I don't think the president can simply cancel an election. We don't talk about this very much, but on September 11th, 2001, that was an election day in New York City. And the primary was suspended because of the attacks. And then everybody seems to have forgotten this. But Rudy Giuliani, who was the mayor and was a tremendous leader and doing a really good job as mayor, even was holding things together through this crisis, even if he's gone off the deep end in recent years. But there was this moment that might have suggested what was to come, because he said sometime in later September, maybe we should just not have a mayoral election. Maybe I should be mayor for another year or another term, because it would be too difficult for the city to transition leadership in this moment.
Jeff, he's foreshadowing.
It really was. I mean, looking back on it now, it has a much different cast than it did at the time. But even then, this idea went over like a lead balloon, and he immediately backtracked. And they did hold elections. They reheld the primary in September. They held elections in November, and they transitioned leadership. People in this country take voting very seriously, and they don't like it when folks try to mess with it, even when they're trying to mess with it for good reason. Remember closer to home, in 2020, when Wisconsin had the first pandemic election in the United States, it was our spring, April election, right, including a Supreme Court election, and our presidential primary. that April, and we were the first folks who held an in-person election during COVID. Speaker Robin Vos showed up in like a crazy spacesuit and told people there was nothing to worry about. But remember that Governor Evers briefly tried to extend the election. He didn't try to cancel the election. What he tried to say was, we're going to extend the election to allow more vote by mail, to give more people more time to vote so that they don't need to choose between participating in our democracy and exposing themselves to the pandemic. And the Wisconsin legislature went crazy, and the Wisconsin Supreme Court immediately shut that down. It is very, very difficult to cancel or structurally change an election by fiat in this country. I do think that we should be on the lookout, and we should be worried about efforts to override the free, fair election administration that states participate in. We can see that at the federal legislative level. Wisconsin Congressman Brian Stile just introduced the Make Elections Great Again Act last week, which would, try to impose all kinds of things that really have traditionally been areas of state control, and try to limit elections, including national voter ID, including documentary proof of citizenship for all voters at every election, including limits on mail-in voting and early voting. I don't think that that will likely make it through the legislative process and go into effect in time to affect this election. I do think we should be worried around the country about seeing federal law enforcement deployed around or at polling places in ways that could intimidate people, in ways that could interfere with balloting. At the same time, I will note that I was worried about seeing a lot of these things last November when we had elections in Pennsylvania, in New Jersey, in Virginia, and elsewhere, and we didn't see those fears come to pass. So I think that with the help of groups like ICAP, with Law Forward and many of our allies, we are really working hard to identify and prepare for these possible things and create contingency plans. But I, at least, do not take... I'm very sanguine that we will have elections in 2026 and they will not be canceled. Mary, do you see it differently?
No, I agree with you. I think it's about preparing things like, what if there are armed agents at polling places or at early voting places in violation of a federal law, but the Department of Justice is probably not going to enforce that federal law. And that doesn't mean just military, but also ICE or other federal agents, how that's going to impact things. What is there some sort of, recourse for that, a legal option? Also issues like, if there are efforts to seize voting machines after the fact, what are the responses to that? What are the kind of legal arguments that the election administrators need to be prepared for? So there's a lot of work, and I know just at the center of all of this, as always, when it comes to elections, at least in Wisconsin, and a lot of thought being put into that. But I agree, they're going to happen. They're going to happen.
I'm going to add something too that, and then Paul, if you have a comment on this from your angle, but otherwise we'll move on because we don't have too much time and we have more questions. But I think that the electorate is more courageous than it used to be, frankly, and courage is infectious, and all that kind of stuff. So I think that we will be thoroughly pissed if we see something that's going to interfere with our right to vote. And I think that we're going to, even if we have to go to the polls and somebody's with a gun, well, I don't know, maybe we're going to be used to it by then, who knows? But I do think that the electorate, and we're organizing for other reasons. We're organizing to protect our immigrant neighbors. And so we will, I believe, be even more connected to one another by that point, and we will be even more engaged. And groups like Indivisible are getting people out, and these groups are getting people out, and we're just not going to put up with it. Frankly, that's kind of my view. there was something else brilliant I wanted to say, but I've forgotten it. Paul, do you have anything to add? Otherwise, I'll move to the next question. Okay, I'll go to the next question. We have too many to do, but I'm going to go to the one that I think is most interesting, maybe to me personally, because I do work in the area of immigrant rights. Entering a home without a judicial warrant. That is the latest. That is the latest and greatest. Well, maybe not the latest and greatest, but that's fairly new from the Department of Justice. I think it was. It said, "Oh, all we need, we're going to train." No, they're training ICE agents to believe that all they need is an administrative warrant to get into a home and to walk through the door. So, Mary, because you're so good at teaching us the law, can you explain the need to have a judicial warrant in the Fourth Amendment? Can you explain the Fourth Amendment to us and how it's being, incorrectly stated today?
Well, let's just say that general counsel opinion that has come to light through some whistleblowers is completely unsupported by any, judicial precedent, and I think just flat out wrong. People may be, this is not really a legal term, but people may be familiar with sort of the phrase, a man's home is his castle, right? And that is where, if any place is sacrosanct when it comes to the Fourth Amendment and what you need a judicial warrant for is to go into somebody's home. A judicial warrant is a warrant that must establish, have facts in it, sworn under oath by a law enforcement agent or someone else that establish probable cause that a crime has been committed, and that either if it's to arrest a person, the person you seek to arrest is the probable cause that that's the person who committed the crime, and that person is in the home that you seek to go into at the time you seek to go into it. If it's a warrant for evidence, it's that evidence of that crime will be found at the place, the home, let's say, that you seek to search at the time you seek to search it. And it's important that it be a judicial warrant. This is in the Constitution. By the term is neutral and detached magistrate. Magistrate just being a different word for a judge, and that means somebody who is not part of the same law enforcement agency or executive branch agency that wants the warrant. It means a judge that's part of an Article 3 court, which is a separate branch of our government that is outside of the executive branch, and that judge will look at the facts that are attested to him and say, or her, and say, yes, there's probable cause and I'll sign this, or no, there's not. An administrative warrant is just one person within DHS saying, I have probable cause to believe there is a person who is undocumented and unlawfully in this country who is in that house, and that person has a removal order. It's not signed by any neutral and detached judge. It's not signed by even an immigration judge within the executive branch. It is just signed by an officer of DHS. And so there's just that might be good enough to apprehend a person on a street or to issue a detainer to a jail to say, hey, when you let this person out, we might be standing there at the door and pick him up with our administrative warrant. But it is not good enough to go into someone's house. And there's very good reasons for that.
So
let me just add to that, Mary. Hang on a second. So Debbie, in Judge Beery's decision yesterday, he has a very interesting paragraph. He says, civics lesson to the government. Administrative warrants issued by the executive branch to itself do not pass constitutional probable cause muster, period.
I love it.
Yeah.
Love it. So I was speaking to a group, I don't know, last weekend, and we were talking about this, and I said, well, the answer I would give is that don't open your door, but figure out if they're going to bang the door down and they're going to break into your house anyway, well, then stand back so you won't get hurt, right? But then document it because they were wrong, and it's important to document it. And hopefully nobody in Milwaukee is going to have their doors, broken down. We're getting definitely to the end of our time. There's two things that I'm not going to I'm not going to ask about because I have this lightning rod I want to do with you all, but there was a question about excessive force, and if it's already prohibited, why do we need courts to rule on that? I just want to point out to the audience, and we can put this in the show notes, that there is a new bill in Congress that strips DHS officers of immunity, so that will be discussed. And then there's also a proposal for at the state level for a Universal Constitutional Remedies Act that would help in that regard. If anybody has like a 10-second thing to add to that, go ahead and do it. Otherwise, I'm going to move on. Hearing nothing, I'm going to move on. And this last one, the last official question, you guys can correct me if I'm wrong because I graduated from law school 45 years ago. When the Supreme Court overturns a state or federal ruling, is there any room for interpretation or recourse by the state or federal court? My answer to that would be, and you guys can correct me if I'm wrong, this is now almost a layman's answer, is that there's always maybe a way. There's stare decisis, they're saying something is dicta, so that there are ways to try to get around a Supreme Court overturning of a federal ruling. But that's what Paul, being a litigator out in the streets, that's kind of what lawyers and appellate lawyers make their money at doing. Is that a fair statement, or is that an unfair? Somebody correct me. Mary, you're the law professor. Correct me if I'm wrong.
Well, I mean, I wouldn't say that it's like, the stare decisis issue. If they've decided to overrule their own precedent, then they've overruled it. You can't say, oh, stare decisis. You argued that to begin with, but the Supreme Court has told us we don't really care if we decide we're going to overrule, we're going to overrule. And then it's all about distinguishing the case on the facts, right? You've got a new set of facts. Paul and Jeff both know this very well. And, the other side is saying, oh, no, you're wrong. The Supreme Court has said X, Y, or Z. And then I'm going to try to make my best argument for why what the Supreme Court did doesn't apply to the situation, right, just like you would if it was an original ruling and not something, being overturned. Now, obviously, if it's a state statute, your legislature can enact a different statute and try, so there's that kind of way, through democracy and democratic processes to try to respond. And Congress could do the same if it's a federal statute. And Congress has done the same many times in the past when the court has, struck down a federal statute. They come and get at it a different way, or the court changes a ruling on something and they decide they'll legislate to fix that ruling. And I'd say that's probably the best way.
That's fine. So we're going to go into, I gave you warning, the lightning rod, because a lot of what we've heard about today is somewhat distressing. And certainly the lawyer that graduated 45 years ago is like, how is this even, how is this even happening? But I want to go to each one of you, and I want you to say really quickly, what brings you hope? What gives you hope today? And I'm going to start with Paul. Go ahead, Paul.
So look, I've been very concerned about the integrity of our democracy. I've been very concerned at a multitude of levels. We had Chris Christie, former governor of New Jersey and former U.S. attorney. And I said to him, look, I'm worried about our democracy's survival. And he said, don't worry about it. We've had other challenges. We've lived through McCarthy. We've lived through the civil rights movement. Our democracy will succeed. And that really gave me hope in thinking that maybe there is a belief that we're going to overcome this crazy time that we're in right now. But to be clear, I represented the Austrian Jewish community in the Holocaust reparations negotiations. And I had thousands of families who survived the Holocaust. And I had the message back in 2000 when I did that work, we all need to have a lifeboat, because Germany was one of the most advanced societies of our decades, of our centuries, and yet it all fell apart pretty rapidly. So I'm cautiously optimistic, and that's probably the best way to describe it.
Good. I'm not going to end with you then. I'm going to go to... We're not going to end with the Holocaust. I'm going to go to Mary next. We'll leave our hometown Jeff for the last. Go ahead.
Jeff should definitely have the last word. Hey, I think what has happened in Minnesota, I mean, tragic, but if there's going to be anything that comes from these two murders. It is that people woke up, and I don't just mean people on the streets, because Minnesota has been just amazing. Minnesotans have shown up, and it is freaking freezing there, like worse than here, and I can barely go outside. And Paul, you can't even speak to freezing sitting there on your sunny day with your t-shirt or whatever on. Anyway, so they have shown up, but their pressure has finally gotten Congress to start to pay some attention. We have, we have the possibility of some guardrails being baked into this funding bill, some guardrails on ICE. And so this is one of the first times we saw Republican governors coming out, like Greg Abbott in Texas, and saying, I don't really know if I like what's happening up there. So, it has made a difference, and that's because of the people. Lawsuits can go on and on and on. We can have wins, we can have lawsuits. They're important. They're necessary, but they are not sufficient. And what we've seen in Minnesota is what we need to see.
We the people. Okay, I'm going to turn it over, Jeff, for the last word.
Yeah, I agree with that. And if people haven't seen it, The Nation magazine first wrote and then submitted and then published last week a Nobel Peace Prize nomination for the people of Minneapolis, because of the way that they have responded. Not just the response, but the peaceful way, the dedication. It's that kind of, you mentioned before, Debbie, courage. It is the courage that we see from everyday people that gives me hope. The people in Minnesota who are standing up, the voters, as you mentioned, the people who continue to volunteer to be litigants in civil lawsuits. I'm not talking about the people who something terrible happened to them and they have no choice, but the only way that they have recourse. I'm talking about people like you and so many others who come and say, yes, Law Forward, I put my name on that. I will stand up. I will do this. And the number of people running for office in this state, the number of people who want to make things better, the courage we are seeing all around, even in these dark days, is really what gives me hope.
Okay, thank you so much. This has been very enjoyable. I've gone over our time, but it was worth every minute to me. Okay, Cheryl, take it away.
Wow, thank you so much to our panelists. It was every bit as amazing as I thought it would be. And I love that we're leaving it on a note of hope and, giving us some faith in our rule of law. There's still hope. So far, 2026 has been nothing short of harrowing. We've seen heroic citizens gunned down in Minneapolis, and then Pam Bondi's ransom note saying that she would reduce the number of ICE agents in exchange for Minnesota's voter rolls. Ann Applebaum connected the dots perfectly earlier this week. The federal government is using a violent paramilitary to extort an American state, apparently with the intent of influencing the coming midterm elections. If nothing else, this is the moment when everyone across the country should begin focusing on those elections and putting every effort into ensuring that they are fair. Grassroots North Shore's election work has never been more important. We are counting on your help, both financially and with sweat equity, to postcard, canvass, rally, and reach out to like-minded friends and family. And yes, No Kings is March 28th. We need overwhelming wins at the ballot box in order to thwart the voter suppression and election skepticism that are being sown. Plus, it feels better to do something than to hide under your bed. Speaking of voter suppression, we do have one rapid response request for everyone on this call. As Jeff mentioned, Representative Brian Stile from CD1, one of the districts that we are working to flip this fall, introduced the Make Elections Great Again Act. As he noted, the bill poses grave threats both to voting rights and to the right of states to control our elections. Please call your congressional representative and both U.S. senators now to express your opposition to the bill. If you haven't, you can download the app 5 Calls, that's the number 5, CALLS, or go to 5calls.org, and it makes it incredibly easy. It gives you your representatives' phone numbers and scripts for the items that they are recommending you reach out to your legislators about. And one of the current scripts relates to the MEGA Act. Our next event is an in-person gubernatorial candidate forum on May 17th at Nicolay High School. Look for details in the follow-up email to this webinar. Follow our newsletter for our volunteer opportunities in this very important election year. And of course, please donate what you can to support our work. Now I would like to introduce Mark Ennis, our co-chair of the membership committee. He will share a membership moment.
Hi, my name is Mark Dennis. I co-chair the membership committee of Grassroots North Shore, along with Kath Michael. I want to briefly explain just how important organizations like Grassroots North Shore are in this fight in what may be the last chance to save our country. How often in the past year have you looked at the news and felt like this? Yeah, me too. So, what are we going to do about this? Well, we can all stick our heads in the sand, ignoring the massive tidal wave that's about to doom us all, or make a total commitment to help stopping this madman from destroying our Constitution and our country. Where to begin? Become an active member of Grassroots North Shore. Still only $30 for a family, $20 for an individual, $5 for a student. Or make a donation. All donations count towards membership, and this year, make as generous a donation as you can. I know you'll feel good about it, and we know we'll feel good about it. Grassroots North Shore does have the expertise, experience, and commitment to help progressive candidates get elected, like Deb Andraka and Jody Haber-Sinikin, co-sponsoring successful events like the No Kings Rally, and help progressive causes succeed. All of our attention now will be focusing on the 2026 elections. In Wisconsin, we have elections for state Supreme Court, governor, lieutenant governor, attorney general, and numerous state assembly and Senate seats. Nationally, the November elections give us one chance to put up some guardrails and rein in the power of this nightmare. We certainly can't count on the majority in the Supreme Court for help. The House, however, is another matter. We gave that up years ago, says one lemming to another, as they watch the House Republicans blindly following the president over a cliff to their doom. And Grassroots North Shore will be working tirelessly to flip some of these seats. And that could make all the difference between living under fascism with state-sponsored murder or a democracy without all the fear and chaos. I'd like to thank all of you for being here and your support, and my wife Virginia for her sketches. See you on the front line. Thank you again.
Thank you all for coming tonight. We'll let the Raging Grannies take us out. Feel free to clap and sing along at home.
Oh, when we vote by election day, oh, when we vote by election day, be sure to count me in that number. When we vote by election day, when we all vote for democracy, when we all vote for democracy, we will stand as sisters and brothers when we vote for democracy. Oh, when we vote by election day, oh, when we vote by election sure to count me in that number. When we vote 5